Welcome back to the Constitutional Clarion. A former law student of mine, who is now a teacher, asked my view about an exam question set in the HSC Legal Studies examination last week. For those watching from overseas, this is one of the final secondary school exams that students sit to qualify to go on to higher education. The question was this, quote, "In relation to human rights, discuss the extent to which the Australian Constitution reflects changing values and ethical standards," unquote. Now, my first thought when reading that was, it's a bit of a word salad. You've got human rights, the Constitution, changing values and ethical standards. But how do they actually connect together? If you take the question literally, I don't really think a constitution can reflect changing values and standards. At best, one could write that changes to the constitution through referendums in Australia, or changes to the interpretation of the constitution may both concern human rights and reflect changing values and ethical standards. Now, of course, the legal studies students would need to address this by reference to the curriculum and what they've actually been taught. And I have no idea what that is. But I thought it would be an interesting exercise to see how a professor of constitutional law, me, would respond to that question. First, there is the question of whether the Constitution has been changed with respect to how it deals with human rights in a manner that reflects changing values and ethical standards. The Commonwealth Constitution can, of course, only be changed by a law that's approved by the people in a referendum. Indeed, it has to be approved by a double majority, being a majority of the voters overall, as well as a majority in a majority of the states, which is currently 4 out of 6 states. The record of constitutional change in relation to human rights in Australia is not great. In 1944, there was a referendum to give the Commonwealth Parliament power with respect to post-war reconstruction and democratic rights for a period of 5 years after the end of hostilities. It included a power to make laws with respect to, quote, "the people of the Aboriginal race," unquote. It also provided that, quote, "neither the Commonwealth nor a state may make any law for abridging the freedom of speech or of expression," unquote. American viewers might recognise some of the terminology there. Finally, it extended the application of freedom of religion in section 116 of the Commonwealth Constitution so that it would also apply to the states, restricting state laws on that subject. Now, the referendum failed. It failed to win a majority overall, and it failed in most of the states, only gaining majority support in Western Australia and Tasmania. In contrast, the 1946 referendum for providing social services such as unemployment benefits, medical services, benefits to students and family allowances was successful. It inserted section 5123A into the Constitution. Could you argue that this involved human rights and changing values? Well, maybe. It falls more into the scope of economic and social rights as set out, for example, in the International Covenant on Economic, Social and Cultural Rights. So there, Article 9 of the Covenant recognises the right of everyone to social security. And there's also, in Article 11, a right to have an adequate standard of living and to be free from hunger. The insertion of section 5123A in the Constitution could, arguably, have reflected changing values with respect to the need for the government to provide assistance to those in need rather than relying on families and charities to do so. One might argue that the 1951 referendum regarding communists and communism would have affected human rights if it had been passed, and also the values of the day. But it failed overall, and it received majorities in only 3 of the 6 states. Now, what about the successful 1967 referendum concerning Aboriginal people? It was not directly concerned with rights. It had nothing to do with citizenship or voting rights or equal rights, as is sometimes suggested. It merely empowered the Commonwealth Parliament to make laws with respect to Aboriginal people. These laws could have enhanced rights or detracted from rights, or had nothing to do with rights at all. But that referendum also repealed Section 127 of the Constitution. It previously said that, quote, in reckoning the numbers of the people of the Commonwealth or of a state or other part of the Commonwealth, Aboriginal natives shall not be counted, unquote. There's an urban myth that this meant that Aboriginal people were not counted in the census until 1967. But that's actually not true. They were always counted from the very first Commonwealth census, as long as they were in areas that were able to be reached by the census takers. You can read actually quite detailed and interesting information about Aboriginal people from the very first Commonwealth census, which is now all available online. Aboriginal people were only excluded from being counted in official numbers for certain constitutional purposes, mostly transitional provisions about returning money to the states, which were based on population, because of the uncertainty of the population of Aboriginal people in outback areas, but also for working out how many electorates each state got, which again was based on population. Section 127 did not exclude Aboriginal people from voting, nor did it mean that Aboriginal people were classified as flora and fauna, which, by the way, is another truly horrible urban myth. In 1974, there was a referendum to enhance the democratic requirements of elections at both the Commonwealth and the state levels, but it failed overall and in all the states except for New South Wales. In 1988, a referendum that would have extended the rights of trial by jury and freedom of religion to the state level and to ensure just terms compensation when a state compulsorily acquires a person's property was also defeated. It lost overall and in all the states. Another referendum question held at the same time about fair and democratic electoral arrangements at the state level and the federal level also failed overall and in all the states. Most recently, the Voice referendum, which would have established an Indigenous body to make representations to the Commonwealth Parliament and Executive, also failed overall and in all the states. Overall, therefore, constitutional change with respect to human rights has been very limited, and it would be hard to mount a case that it reflected changing values and ethical standards. What about the other way in which the Constitution changes, which is through changes to interpretation? The answer here is mixed too. First, there are few rights in the Constitution, and those that exist have been interpreted pretty narrowly by the courts. Certainly, Section 116 of the Constitution, which deals with freedom of religion, has been interpreted narrowly and quite consistently so by the High Court. It does not seem to reflect changes in values or ethical standards. Section 80 on trial by jury is next to useless, as it only applies to indictable offences, so it can be avoided by simply making an offence one that is not indictable. Its only real effect in recent times has been to require that jury trials have a unanimous verdict in federal matters on indictable offences rather than majority verdicts, which are sometimes allowed in the states. Where Section 80 does apply, the defendant cannot waive their right to trial by jury. It's compulsory. The other important right under Section 51(31) of the Constitution is to receive just terms compensation when one's property is compulsorily acquired. While there have been lots of judgments about the application of this right, it would again be, I think, quite hard to say that they reflect changing values and ethical standards. It is in the area of implied rights where an argument about changing values and ethical standards might be made. Implications are more flexible than express rights, and therefore they're more susceptible to interpretation that reflects values and ethics. The key implication here would be the implied freedom of political communication. It has been interpreted in ways that not only restrict parliaments from enacting laws that limit political communication, but also to allow laws that do limit political communication if they are enacted for legitimate purposes that are proportionate in nature. Cases such as the Monis case, which involved offensive letters sent to the grieving parents of dead soldiers, and the Club case about laws establishing safe zones around abortion clinics, could arguably be regarded as reflecting changing values and ethical standards. Implications concerning voting rights are also relevant here too. In the Roach case, the High Court held that some prisoners could vote in federal elections, and also accepted that laws which banned people from voting based upon irrelevant factors, such as their race or sex, would not be constitutionally valid. Now, that is certainly a change from the views that were taken back in 1902 when election rights were enacted. There, such laws would have been regarded as perfectly valid, subject of course to the application of Section 41 of the Constitution, which the High Court, in another case, basically interpreted out of operation, but that's another story which I won't go into here. It's possible also that the examiners, in relation to this exam question, were angling for students to make reference to the Love and Tom's cases, which concerned whether people who met the definition of being an Aboriginal or Torres Strait Islander person, but who were not citizens of Australia, fell within the scope of the aliens power in the Constitution. The case did not strictly concern human rights. It was actually addressed to the scope of the Commonwealth's legislative power. But as its practical effect was to prevent certain non-citizens from being deported from Australia, it might arguably be a case that could be drawn upon. The other possibility might be the NZYQ case about whether non-citizens can be detained indefinitely in immigration detention if they cannot, in practical terms, be deported to another country. As some of you will know, I've done a couple of videos on the NZYQ case before. In short, the court held that non-citizens may be detained for the purpose of deporting them. But if there's no real prospect of a detainee's removal becoming practicable in the reasonably foreseeable future, then they are no longer being held for the purpose of removal, and their detention must then be for the purpose of punishment, which is outside the power of the executive government. Whether you characterise this judgment as reflecting changing values and ethical standards, or whether you see it as merely reflecting the existing constitutional limits on executive power, which stem from the doctrine of the separation of powers, is a matter for debate. So, in answer to the exam question, I guess a student could have discussed some or all of these things relating to referendums and constitutional interpretation by courts, but overall I think it would be rather hard to mount an argument that changing values and ethical standards have actually had much of an effect upon the treatment of human rights under the Constitution. Maybe a little bit, but not a lot, unlike the position in America, which is much more pronounced. Now, for those of you who actually did face this question in an exam and didn't answer it the way I've suggested, don't panic. The people making the exam may well have a completely different view on the matter based upon the curriculum and the relevant materials that have been provided to students. So just take this as an interesting outsider's view of the question. It's an intellectual experiment, not a judgment on what you have written. As for the rest of you, I hope you found it thought-provoking. Maybe you would answer the question better than me. Thank you again for watching the Constitutional Clarion, and as always, I look forward to seeing you next time. Goodbye.